Just like, again, any other occupation, lenders will also market and advertise certain loans, trying to lure consumers to use them. And they also have some regulations and laws they must comply with when they are advertising. The main thing I want you to see right here, and that only matters about what we're getting ready to talk about, there are what we call trigger terms that if the lender should use certain terms in their advertising, then there are some other disclosure requirements that must go with those terms. In other words, is basically what the law was saying is this: you can't say give part of the story and leave the part that maybe not so good out. So if you're going to advertise something, you got to advertise the whole story, not just the part that might be appealing to a consumer. Well, what are some of these trigger terms that would require additional disclosures? Well, if they put anything in their advertising about the amount of a down payment that might be required, the amount of a payment, the number of payments, period of repayment, or amount of any finance charge. So it sounds like to me, pretty much if they indicate anything in their advertising about payments, there's additional disclosures that must go along with it. And what those disclosures would also entail or would require, the amount or percentage of a down payment, right? That would have to be included. The terms of repayment, and what that annual percentage rate is going to be. Y'all, that one's critical. That's what I've been, for the last several modules here, I've been kind of harping on this. Y'all, that's what people need to pay attention to when they're borrowing money. The APR, not necessarily the interest rate. The interest rate's not what it's going to cost you to borrow the money. The APR is what tells you how much it's going to cost to borrow money. So lenders always have to provide that. It's just they never discuss it. They never talk about it. They only want to stick with the interest rate because they really don't want to get into all the other costs associated with the loan. So if there's much difference between whatever the interest rate you're getting and the APR, y'all, that means they are eating you up in cost. So, I would try to find the loan or the lender that's going to give me a loan where my APR is pretty close to the interest rate. It has to be at least the amount of interest rate, but it's typically going to be a little over. But it shouldn't be a whole lot more. But anyway, that's how you should be comparing these loans. So just make sure basically if they use any trigger terms in their advertising, especially pretty much anything to do with a payment, then they must also disclose how much that payment would be, or at least some percentage of what that down payment would be, terms of that repayment if they bring that up, but has to include what the APR might be. Okay? All right. So that's advertising. Now we need to talk a little bit more about this TRID. We kind of touched on it a little bit in the previous module. Remember, TRID just stands for TILA-RESPA Integrated Disclosure. Because when they combined the truth in lending, which is what TILA is, they combined TILA with RESPA to come up with these TRID disclosures. There are a lot more disclosures required now that TRID is in place. So let's look at those. One, and some of this we've already touched on, but TRID replaced the HUD-1. The HUD-1 used to be the settlement statement we would use for closing, but they replaced that with the closing disclosure. Because the HUD-1 was just one document that had all the buyer information and all the seller information all on the same document, and each party got a copy of it. That was always a terrible idea as far as I was concerned. But now they've separated it, and now they call it closing disclosures. The buyer gets their closing disclosure, and the seller gets their closing disclosure. But what is really critical about this disclosure, especially the buyers, y'all, by law, and this cannot be waived typically, y'all, this cannot be waived. Y'all, the buyer must receive a copy of their closing disclosure a minimum of 3 business days prior to closing. Y'all, and that has to be provided by the lender. So the lender has got to make sure that happens. And typically it's going to be like a certified email, because the lender has to be able to document when the buyer actually received this closing disclosure. One thing that a good agent needs to make sure they tell their buyer is, y'all, especially when you get up, say, a week prior to closing, buyer, you need to routinely be checking your email, because the lender's going to, at some point, very soon, certainly within a week, and it's got to be within prior to 3 days of closing, they're going to email you the closing disclosure. And and again, this is typically like a certified email. This is not just a regular email. And when you click on it and open the email, then that goes back to the lender, and they can document now that the buyer actually, or when the buyer received it. Y'all, I'm telling you, and this happens a lot, where the lender sent it, say 4 or 5 days prior to closing, but the buyer never checked their email, and maybe they didn't open it until a couple of days prior to closing. Well, you're going to have to reschedule closing, because y'all, there has to be a minimum of 3 days from the time the buyer actually looks at the closing disclosure before you can close. So you got to be checking that email. All right. The other document that was replaced, remember we said they used to provide what we call a good faith estimate, where they listed the cost of the loan. It's just they never included all the cost. But now they have, actually they don't call it a good faith estimate anymore. They call it a loan estimate. So the 2 documents primarily that have been changed for closing is the closing disclosure and the loan estimate. Y'all, they've changed the documents that's required for closing now. But now, if you recall, y'all, with the loan estimate, y'all, when they changed that, they also required that the cost you identify on that estimate, they must be accurate. Again, so all the costs there, the APR has to be there, and it cannot change. Y'all, there may be like an 0.1% exception in some cases, but it should not change, or at least should not change much at all. In fact, I'll just tell you, whatever they put on that loan estimate, the lender that is, whatever they put there, if the costs actually are more than what they put on the loan estimate, the lender will have to eat that cost. Okay? Because they can't charge more than they put on their loan estimate. All right. So what transactions are affected by these new TRID disclosures? Any closed-end mortgages are affected. Remember, we talked about, again, in an earlier module, the difference between a closed-end mortgage and an open-end mortgage. Remember, a closed-end mortgage is, you make your payments on it. Once you make your payments, the loan goes away. It's just gone. But if it's an open-end mortgage, you can actually make your payments or pay off everything you owe and then pull it right back out and use the money again, right? That's what they call it. It's an open line of credit, the HELOC, if you will. So open-end mortgages are not affected, but closed-end mortgages are. But then you'll notice, there's 3 specific types of loans that the law actually exempted from these disclosure requirements. And I got to tell you, one of them in particular really concerns me, but it is what it is. But what's exempt from TRID? Y'all, HELOCs, y'all, that home equity line, of course we know because that's an open-end mortgage. Loans for mobile homes, which y'all typically mobile homes are considered personal property when they're purchased. So that would not apply, or probably shouldn't apply, and it doesn't. But the one that concerns me is this last one, that reverse annuity mortgage, or that RAM. Y'all, honestly, in my opinion, I can't think of another loan that should require more disclosures than this one. Y'all, if you don't remember the RAM or reverse annuity, y'all might want to go back and review that. But y'all, that's the one where you have to be at least 62 years of age, and you can borrow money basically against your home, and you do not have to pay it back as long as you're living in the home. But y'all, you better understand what you're doing there, because anyway, y'all, I'm not a big fan of that loan, and it strikes me that the government decides this is one of those loans you don't have to make these disclosures. But anyway, so those three are exempt from TRID disclosures. Now, some other disclosures that are required, y'all, prior to closing. One of those is if you have it in what we call an affiliated business arrangement. Now, typically, the real estate agent shouldn't have anything like what we're getting ready to talk about, but it is very common that the company you're licensed with will have what we call affiliated business arrangements. And what they'll do is this, where a real estate company might go into business with a lender. Remember, a lender cannot kick back. Y'all can't pay anything for referrals. Y'all, that's a kickback. That's a no-no. We've already talked about that. So, in essence, we've kind of figured out a way to get around this requirement or this law. And so they'll form a business entity that maybe the lender will own half the entity and the real estate company will own the other half of the entity. And basically saying any loans that are processed through this affiliated business arrangement, y'all, because the real estate company actually owns a portion of the entity, then they can actually claim some of the profits from the loan. So the real estate company would, in addition to getting paid a commission, would also receive profits off of the loan if they used that lender affiliated with the real estate company. Again, now that's legal, but that is something that has to be disclosed. And the way you hear, what you'll hear a lot of times is agents will tell buyers, if you're looking for a lender, we actually have an in-house lender, and be glad to set you up with them if that's something you would like to do. Yeah, and that's fine as long as you tell that buyer, if you use our in-house lender, we do have an affiliated business arrangement with that lender so that some portion of the profits from the loan will also go to the real estate company. Now, it's not going to go to you as a real estate agent. It goes to the real estate company. But you must disclose that to the buyer as long as they're okay with it. And y'all, if it's a good loan, maybe they got the lowest APR, then, I could care less who gets some of the profit. But that is a disclosure requirement if you have an affiliated business arrangement like that. But then here's some of the prohibitions. Again, we've already talked about this, but it says, it prohibits a real estate agent from receiving, and notice they put in here in quotes, anything of value in exchange for referring a client to, or anybody for that matter, to a settlement service provider, or SSP. Remember, the settlement service provider, anybody providing a service, the attorney, lender, appraiser, whatever. Again, there's nothing wrong with you referring your client to a service provider, but you cannot receive anything of value in exchange for that referral. Y'all, that would be considered a kickback, and that obviously is illegal.